Now, I would like to welcome all of you today. Our ASL interpreter is Craig. Craig, please say hello. And our real-time card captioner is Chevelle. So please be sure to turn on your access to our interpreter and your closed captions. Please also note that this webinar is being recorded and it'll be made available to anyone interested after the event. So if you do not wish for your image to be recorded, please turn off your camera now. This is also an opportunity right now, if anyone is having issues seeing the interpreter or seeing the presentation or the closed captions, now is the time to reach out and send us a chat, and we will try to address that immediately before we begin with the content. And Fred, I will count on you to pick up those comments and let me know if we have to pause. So, let me welcome you to today's presentation. It's on ADA compliance for educators. And our primary audience today is educators and administrators from among our current clients all over the United States. We also have newcomers from outside our clientele, and we welcome you very warmly. My name is Adam Karish, and I'm the Chief Executive Officer at Karish.com. Karish has its headquarters in the Philadelphia area. We conduct hundreds of remote accessibility service sessions every week, and we've been serving the community for 40 years. So with clients in all 50 states, in varying industries, and 24/7 in-house tech support, our team is really made up of experts in accessibility services and remote solutions for ADA accommodations, and in particular for the deaf, the hard of hearing, and the visually impaired communities. And I am joined today by Michael Torsha, Esquire, who's an experienced attorney and presenter as well. Michael, why don't you say hello?
Hello, everyone. This is Mike Torsha. I'm from the law firm of Seminoff, Ormsby, Greenberg, and Torsha, right outside of Philadelphia in the suburbs. I've been a labor and employment attorney for almost 30 years and happy to be here today with you.
Great. And so very briefly about today's presentation so you know what to expect. So with Mike's help, today's presentation will highlight legal liabilities by using case studies resulting from the ADA law in education with a special focus on the deaf, the hard of hearing, and the visually impaired communities. But we'll also be presenting how to kind of navigate avoiding these potential legal liabilities with practical solutions. This event is part of a series that we've titled ADA Compliance in Practice. And the series focuses on the relevance of ADA law for the deaf, the hard of hearing, and the blind. And each session showcases legal and practical implications of individual ADA law titles. And today's meeting will be covering Title III in particular. And our next free session, which happens to be tomorrow, will be focused on Title I. And the applications of ADA compliance in employment law. So we welcome any of you that might be interested to join us for that as well. We will end this presentation with a short Q&A session that'll last 15 minutes. And if you have any questions, though, during the presentation, please feel free to ask them. There's the chat box to the side of your screen, and we'll do our best to get to any of your questions during the presentation. If we can't, then we will handle them during the Q&A session. We'll be muting your mics as well to avoid distracting any other participants, but your chat box, as I said, should be functioning and should remain active the whole time. So Mike, why don't I hand over the beginning of the presentation to you?
All right, Adam, thank you so much. So I'm going to start by talking about the ADA just generally, and some of you are familiar with the Americans with Disabilities Act already in certain ways. Let's just have a kind of quick refresher, ADA overview. So the ADA was passed in 1990. It's a federal law. It's not a state law, although there are many states that have equivalent disability statutes. passed in 1990. And in 2008, there was a very important amendment to the ADA. Some people call it the ADA-AA, or you can just call it the ADA amendment. But in 2008, there was an amendment that greatly expanded the definition and the scope of a disability, of what exactly is a disability. So now a disability is really almost anything that someone has, a health condition that's chronic. If it's something temporary, the example we use very often is a broken leg is not a disability, or an illness that is going to get better is not a disability. But many, many health conditions are considered to be disabilities. The ADA has 5 sections to it. You'll see that on the screen. We're going to be talking about the 3rd section, center screen right there, Title III, public accommodations. So public accommodations under the ADA, what does it cover? It prohibits disability discrimination and requires access at places of public accommodation. Those two things really go hand in hand. You can't discriminate against someone who has a disability, and you must provide certain access in places of public accommodation. Now, I will say that what we're talking about today, Title III, is different from the title that many of you may be familiar with that protects employers and employees. That's Title I. And as Adam said, we're giving a presentation literally tomorrow on Title I for employers and employees. So that's something separate. We're only talking about public accommodations today. A public accommodation is any place where the public goes. So for example, the second paragraph on your screen right there, restaurants, movie theaters, schools, daycare facilities, on and on. It does include places where people work if the public goes into those places, such as office buildings, factory, warehouses, etc. For today's purpose, it's important to know that a public accommodation also covers colleges and universities, schools, and importantly, communications coming from colleges, universities, schools. That includes online courses, internet, and school announcements. And we'll hear more about that, the type of communications, when we talk about some of the case studies in a little bit. Let's jump right to the bad stuff. What happens if you violate Title III of the ADA? This is a commonly asked question. All right, so we violate it. We don't provide an accommodation, or we discriminate. What could happen? Well, there could be an investigation. There could be a compliance review. There could be a private lawsuit by the person who is alleging that they did not get the benefit or they were discriminated against. And there could be lawsuits by the Attorney General's office. The statute itself provides that the Attorney General can file suit. And what can someone get, or what can the Attorney General seek? They can seek the relief that's on the bottom left there. An injunction. Temporary, preliminary, or permanent injunction. That means stopping someone from doing something or forcing them to do something. Providing an auxiliary aid or service. And you're going to hear more about that in just about 1 minute, about what an auxiliary aid or service is. Or modifying your policies or your practices. Of course, making the facilities accessible. That would be a remedy. There are monetary damages. There are civil penalties. There are punitive damages. Punitive damages, some of you know, are punishment against a company or an entity or a school for intentionally not providing an accommodation that it knows it must provide. And then there are attorney's fees that can be awarded to the person who's bringing the action. A little bit more about penalties, and this is an important concept for today's talk. The courts take into consideration good faith efforts to comply. In other words, it matters if you're trying to be good, if you're trying to do the right thing. So often it seems like it doesn't matter. But in this context, it does matter. If you are trying to provide an accommodation, and for whatever reason it doesn't work, or the person is not happy with that accommodation, it doesn't mean that you won't be ordered to maybe provide some accommodation. But when it comes to penalties and paying attorney's fees, good faith efforts do count. Courts will also consider whether an entity could have anticipated the need for an auxiliary aid. Did you know about it? Or could you have anticipated it? Or should you have known about it? Many people here at the seminar today, just by virtue of sitting in here today, you are gaining a certain level of knowledge that you are, to provide certain accommodations. So this means if you knew the disabled individual needed an accommodation but did not provide it, there could be, or there would be, larger civil penalties. So let's talk about those auxiliary aids and services. What do we mean? What is that? Some of these slides coming up, there's lots of text on the slides, but as Adam mentioned, this is being recorded and it can be made available to you later. So that's why, we're not going to read every word of this, but we do want you to get some of the basic information. So when the ADA talks about auxiliary aids and services, the basic rule, really common sense, no individual with a disability can be excluded or denied services or segregated or treated differently because you don't have, or because of the absence of, auxiliary aids and services. That makes sense. However, there's an exception to that. No one has to provide these services if it would alter the nature of their goods or services or facilities or privileges. And I have to say, this is very confusing to many people. And it's actually, little known secret here, it's very confusing to employment lawyers like us as well, because the cases that have decided where there's an exception are really all over the place. So for example, there's a case that says that a bookstore was not required to fundamentally alter its business because it didn't ordinarily special order a book, and someone asked for a special order. I mean, really? Is that really that difficult to special order a book, for a disabled individual? I would never have guessed that a court would say that it would fundamentally alter the nature of the store just to special order a book. There's a similar case where a court said that a restaurant is not required to prepare a special dish for someone who is disabled, like a special order, like we all do every time. I'll take this, but, I want the sauce on the side or something. Once again, these are seemingly so minor, you wouldn't think that would violate, or that would be an exception to the rule. There can't be an undue burden. So there's another case where a court said the business was not required to buy a building, to literally purchase a separate location. Okay, that we understand. That makes sense. You don't need to buy a building for someone. But the other things, it's a little confusing. So continuing with the basic rule here, the next slide, the public accommodations shall furnish the auxiliary aids when it's necessary to ensure effective communications with people who are disabled, individuals with disabilities. So you need to provide some sort of accommodation so they can communicate, you can communicate with them. But the statute also says that the method that you use or the accommodation that you provide will vary according to the person. And there's lots of factors here, as you see at the bottom: the nature, length, and complexity of the communication, the context in which the communication is taking place. So the statute doesn't say you have to use any particular auxiliary aid or service. It just says you have to provide something that works. Wow, look how many words are on this slide. Not going to read it, but we're trying to impress you with how complicated the statute is. So if you look at this slide and you see some of the bold letters and the bold words in the middle there, auxiliary aids and services, in quotes, is defined as all of this stuff, but includes open and closed captioning, including real-time captioning. And then if you go to the sort of little further down in the middle, it also includes braille materials and displays. So once again, it can be many, many things, and it includes these things. Nothing in the text of the ADA specifically requires the use of closed captioning. You just saw that that's just one of many, or visible text or subtitling, because it's flexible. The statute's flexible. However, many of the alternatives other than those these days have been replaced or disfavored. And Adam will talk about it in a minute. Some of these methods are just no longer used. So you really need to rely on what is out there, what's available, what works. and what is cutting edge. So with that, I will let Adam talk about the public accommodations and the online learning piece here, and I'll pick it up a little later when we give you a couple of case studies.
Great, Mike. Thanks a lot. Right. So a little caveat here. So Title III requirements that we're talking about today are equally as relevant to on-site educational settings as they are to online learning, which is relevant for all of you today, I think. So as we'll discuss during the case studies in more detail coming up, these requirements include, your pre-recorded coursework, as well as live classes, as well as all of the school's content that's showcased online, whether it's audio or video content on any of the school's domains or third-party web platforms. Before I continue on with this slide, I would just like to check 100%, be 100% sure that all of the participants actually can see our ASL interpreter and can see our captions. So I would be really grateful if all of the participants could just go onto the chat and just say, yeah, it's great, I see it, or something to that effect. If we have anybody who can't, please speak up and let us know, because we did have a slight difficulty there at the very, very beginning. I just want to be sure everybody has access. So thank you very much. Right, so where was I? So what you do have to remember is that upon a specific request by an individual who is unable to access specific content, your school is basically obliged to provide accommodations for any new video or audio content created or produced by the school and posted on any official channels, such as the school's website, official YouTube or Vimeo, SoundCloud channels, etc. This is relevant for the school, for the school's museums, for libraries, and for legacy content. And we'll talk about legacy content in one of the case studies. So one of the settlements we'll discuss specifies that the schools must provide what's called industry standard live captioning for all live events and for their live streamed events as well. So that goes for the video and the audio, which is live streamed over the internet. And this is relevant for what? Commencements, ceremonies, presidential installations, and all other sorts of events that we might consider high interest. So in the case of MIT and Harvard, the settlements that we'll be delving into later, the schools are given just 5 business days to provide the content after receiving the requests that I spoke about. So that is really not much time at all. So we'll be talking about how that's relevant to you and how it might not be relevant to you in a little bit more detail in a second. So all of this has surely raised some questions, but don't worry, we'll dig into the details in a moment. So permissible accommodations. So the ADA law, as Mike was mentioning earlier, stipulates a specific list of auxiliary aids and services, otherwise referred to as accommodations. Now, the federal regulation proposes a long list of very specific accommodations, but that list includes, as Mike was saying, in some cases really arcane or outdated recommendations such as telephone handset amplifiers, or simply exchanging of written notes. So that's really quite outdated. Several, though, are mainstream, very popular, and used commonly among universities, colleges, high schools throughout the U.S. And here, what we're going to do in this upcoming section is I've outlined 4 of what we consider the most universal solutions that are most often provided on-site as well as remotely for distance learning. So let me emphasize that based on our experience with the schools in all 50 states, all of these examples are equally relevant solutions, both for on-site teaching as well as for your distance learning scenarios. So I'm going to walk through 4 kind of baskets of services. or accommodations. The first will be the basket of real-time captioning. The second is transcription and note-taking. So that's primarily for pre-recorded audio files. The third will be qualified interpreters, on-site and remote. And the fourth is dedicated services specifically for the visually impaired. So the first basket is real-time captioning. This is oftentimes referred to as CART captioning. Now, CART captioning, I'm sure a lot of you are familiar with. It is perhaps the most ubiquitous and inclusive accommodation for the deaf and the hard of hearing communities during live events, as well as online learning, classroom teaching, and commencement ceremonies. So CART is an acronym, and it stands for Communication, Access, Real-Time Translation. And it's the process of turning the spoken word into captioned text. Now, CART is provided in real time for individuals or for groups of any size in any setting. So the speaker's audio is transmitted from the microphone to our certified captioner, just like it's happening today, and it's displayed as text on a large video screen, on your monitor, or on your laptop computer. And as you're seeing today, the accuracy is 97, 98%, and all of that happens within 2 to 4 seconds. So it's almost immediate. Within the real-time captioning category, we also have internet captioning and live streaming. And that's for all streaming events, all streamed events, and that are streamed on the internet, as well as uploaded videos that are put onto platforms like YouTube, Vimeo, etc. The last one that we'll include here in this basket is what we call meaning for meaning captioning. And meaning for meaning is a real-time conversion of speech into summarized text. So it's not verbatim, but summarized for individual users most often. The service is really used most often in education, often for meetings. For example, we do this for municipal meetings and other types of appointments in business settings. You might have heard of Typewell or Cprint, but they only refer to, those are names of specific software that meaning for meaning is provided in. So in terms of the end user's experience, Typewell, Cprint, they are both identical to one another. Also in this basket is what is called broadcast captioning. It requires also a specialized type of software and exceptional skill on behalf of the captioner. And we most often use broadcast captioners for programs on television, large-scale events, public events, such as today's. Oftentimes we'll just use a broadcast captioner if it's requested by the client. The next slide is the second basket called transcription, note-taking, and offline captioning. And as I mentioned, this is for pre-recorded audio files. So transcription is the creation of a 100% accurate verbatim transcript from pre-recorded audio or video files. Note-taking, on the other hand, is a little bit like meaning for meaning. It's the process of taking the verbatim or summarized notes from lectures or meetings and presenting them in some type of a readable format. So when it comes to note-taking, there are really myriad formats, levels of accuracy, and turnaround time available. It really depends on what a given school or a student needs. Offline or closed captioning is basically closed captioning for pre-recorded materials, and it's used for broadcast and internet videos. The captioning on these can basically be turned off, and hence the name, offline captioning. Open captioning, on the other hand, is a lot like closed captioning. The difference is that it cannot be turned off. These are oftentimes called subtitles. So the third basket that we'll be talking about is qualified interpreters. That's for on-site or remote. I've chosen two types of interpreters to talk about here in this section. One is American Sign Language, ASL, which Craig is doing for us today. And As I mentioned, ASL can be provided on-site or remotely in the classroom for business meetings, at events, etc. You only want to permit trained and certified ASL interpreters to cover your classes or your meetings. That's the only way to ensure that the best real-time service is available to you. Otherwise, you really don't know what you're going to get. The second is tactile ASL, or tactile signing. And tactile signing refers to signing using touch. It's a common means of communication used by the deaf-blind, and it's based on sign language or another system of type of manual communication. And a little story for you is that directly before the COVID-19 repercussions hit, our team participated in a placement process, and we helped a deafblind middle school student in Pennsylvania, and she required basically a full-time tactile ASL interpreter in school with her every single day. And we were able to send out several really strong candidates almost instantaneously, which was an exciting project for me and my team. But the reason I mention that example is because it's really important to keep in mind that the accommodations that you select have to be really attentive to your students' specific needs. So some people are, for example, late deafened, meaning that they're not born deaf and they don't know ASL. So captioning is a better option for them. Those fluent in ASL, on the other hand, they oftentimes take great pride in their unique language and their culture. And for many of them, they don't consider captions as a real alternative to ASL interpreting. And in some cases, as in the case of today's webinar, both is often the best option. So it's really a case by case. This last slide is for dedicated services for the visually impaired. And I'm just presenting two samples here. The first is a real-time Braille cart, which some of you might be familiar with. What we call Braille cart is provided, again, by a certified expert cart captioner, who then connects to the individual student's Braille reader. And this allows the end user to interact in real time in any environment. It's worth noting that real-time Braille cart is not a fully remote service. Audio description. Audio description is an interesting service for the visually impaired. It's basically the process of narrating the actions or events that are taking place in a video or at any live event. So until COVID-19, we provided this service for training seminars, plays, theatrical productions, etc. Currently, it's primarily ordered for pre-recorded materials rather than for live events. So now we move on to case studies. And I guess this is where I hand it off to you for a few minutes, Mike.
All right, thank you, Adam. So we're going to be talking about just 2 or 3 case studies that are of interest and kind of make the points that we're driving home today. The first case study is really 2 cases, and these are combined cases or consolidated cases that were brought by the NAD, by the National Association of the Deaf. One case was against Harvard University. The other case was against MIT, Massachusetts Institute of Technology. If you're familiar with those schools, you know that they're very geographically close. They're both in Massachusetts. And that's what these were. They were class action lawsuits brought on behalf of anyone in the class of people who would be affected. And it was brought in federal court in Massachusetts. And the plaintiffs, the NAD and the people that they represented, they argued that the failure of these schools to provide equal access for the deaf and hearing impaired individuals to much of their audio and audiovisual content needed to be accessible. They were not accessible. So the colleges were making certain content available to the general public, but they were not providing equal access for the deaf and hard of hearing. They argued that the colleges violated the ADA Title III, specifically what we're talking about today, for the lack of quality and comprehensive video captioning in their online courses, the acronym there, MMOC, that was made available to the public. The other side, the schools, the defendants, argued that their websites and the other online content were not places of public accommodation. So they basically argued to the court, the ADA doesn't even apply to our websites and the online content. And they said, the schools said that the online content was not a, quote, aid, benefit, or service requiring equal access. And those are words under the ADA. So really, it was not an argument about whether the accommodation was sufficient or not. It was pretty much understood that what the schools were doing were insufficient, but it was more of a legal argument of, does the ADA even apply to this? They went to certain definitions for caption and for captioning, and they determined that this was the definition that they used to try to figure this stuff out. And again, lots of words here, but what we really want you to focus on is the bolded text down at the bottom, that caption or captioning means that you have to produce these things in a manner consistent with industry standards. I think Adam used that term before, with industry standards. So it's not enough just to provide anything on that long list, that other slide with all the, the long list in terms on it. You must provide something that's consistent with industry standards. So what happened? Well, the case is settled. Even though they were combined with one judge in one court, they settled separately and at separate times for different things. So the Harvard case settled in November of 2019, so whatever that is, 14 months ago or so, with a settlement agreement, or under the court, they called it a consent decree. The MIT case settled in February of 2020 in this year. Just before we get to that, I'll give you a little more detail about what it settled for. Interestingly, the MIT case was not binding on other lawsuits. Settlements never are, by the way. They're not binding. You can't go into court and say, well, this guy, 2 years ago settled for this, so I should get that. But in these types of cases, these class action lawsuits, high profile cases where a lot of these issues are being sort of argued in the public, it's very persuasive. These settlements are very persuasive, and there's every reason to believe that a court or a settlement would be very much along the same lines. MIT was hit with attorney's fees, with over $1 million worth of attorney's fees. Harvard, I think, had $1.5 million in attorney's fees. So let me, Adam, I think you wanted to talk about the resolution here, right? How this worked out in real life.
Yeah, very briefly, I'll touch on that. So like Mike mentioned, as of February, I think 2020, the NAD versus Harvard and the NAD versus MIT lawsuits, they each settled through consent decrees. So what's interesting here is how it affects all of us, not just the NAD, MIT, and Harvard. And so according to the NAD, the National Association of the Deaf, both settlements represent, and this is a quote from the NAD, the most comprehensive set of online accessibility requirements in higher education that provides a new model for ensuring worldwide online and digital accessibility in academia and business for people who are deaf and hard of hearing. So that is a huge statement, and it's the truth. These cases have set a new standard for educators as well as for the business community. And that's really what I wanted to highlight here, and I wanted to touch on a couple of those relevant items. So although the NAD versus Harvard settlements and the other settlement, they can't be treated as specific precedent for other cases, they are high-profile cases, and they do give us useful behind-the-curtain looks at sample situations that could be similar to ones that your school might find itself in. So in these cases, it took, 4 years of litigation to reach a settlement. But the silver lining is that all that litigation strengthened Harvard's new digital accessibility policy, and it established, captioning guidelines so that Harvard University could continue to improve accessibility for its online resources for those who are deaf and hard of hearing. So that's all great. But it's worth noting that Harvard had been captioning much of its online content prior to the litigation proceedings. So importantly, the settlement guaranteed that the university had to provide high-quality captioning services for online content from that point on. So what's important here? We have to look at what high-quality industry standard captioning really means. So let's take a closer look at that stipulation of the settlement. So a school or their selected agency, they need to put in years of consistent work into maintaining industry standards by ensuring accuracy on the one hand and certifications on the other. And you can do this a few ways. The first is demanding of captioners that they have the appropriate certifications. The second is by applying the proper internal vetting procedures when you select your interpreters or your captioners. The third is a little bit like I was speaking before with the tactile case, is matching the captioner's experience or the interpreter's experience to the particular needs of a particular deaf student. Now this case study, the ones that Mike was just walking through, they refer specifically to offline materials, so that's pre-recorded content. For pre-recorded materials, the expectation is nothing less than 100% accuracy in the captions. And assuming you need an SRT file, which is basically a record of the event for publishing purposes. If you want to put it on social media, for example, you'll need a professional speaker diarization, you'll need the timed-in captions, etc. So it's worth noting that the same standard basically applies to American Sign Language interpreting too. But in real-time scenarios, high-quality industry standard refers to the accuracy level of no less than 97, 98% for real-time events, or real-time captions, I should say. And the second item I mentioned was certifications. So in order to provide high-quality industry standard services, captioners require years of training. They require specialized software and hardware and national as well as often state certifications. So for exactly those reasons, there are some artificial intelligence solutions out there which are all asynchronous at this point in time. They simply do not meet what we would consider industry standards for real-time scenarios. Now, I think at this point, I'm going to hand it over to Mike again to go through the second case study, and then I'll comment on that as well.
Thank you, Adam. Before we get to this case, the Argeni case, I do want to interject, one thing. So just going back to this one for a minute, this case here, the National Association of the Deaf, as I mentioned, these are class action lawsuits, 2 class action lawsuits brought in federal court. And just recently in December, just about a month ago, there was another class action lawsuit brought against, here we go, Zoom, the very platform that we're on right now, Zoom Video Communications. The 2 plaintiffs, Kane and Myers, so the case is called Kane versus Zoom Video Communications. But basically, this is exactly the type of class action lawsuit you see, nowadays, but they've been going on for a long time. Kane is a hearing impaired individual who relies upon auxiliary aids and services to communicate. And Zoom, the platform that we're on, charges or imposes a surcharge for providing those services. So the class action lawsuit against Zoom is saying, well, wait a minute, why would you charge us more for that? This is a public accommodation. It's under Title III of the ADA. And you have a responsibility of making this platform accessible to the hearing impaired for no extra charge. You can't discriminate against us by charging more, if you will. So that was just filed a month ago. So there hasn't even been, any kind of real proceedings on that case, but we'll be watching that case to see what happens. You can bet that the outcome of that case against Zoom will have, long-reaching effects on other similar platforms that charge. Okay, so going from those big class actions against the high-profile defendants and the university.
Sorry, Mike, do you mind if I interject just one thought?
Sure, go ahead.
From my reading as well, if I might be mistaken here, but my understanding of that case is there was a second component to the charge against Zoom, is that the quality of the captions that costs $200 or something an hour were also poor quality. So it wasn't just the fact that it shouldn't be charged for at all, but also that the quality has to improve. So again, we come back to this whole quality issue. It's not just throwing any old captions at the screen and, just hoping it'll be okay. But it actually has to be understandable for the deaf and the hard of hearing communities.
Right. You can bet that there will be lots of discussion about the auxiliary aids and services meeting industry standards in that case. No question. That's right. If the quality is insufficient, then what's the point, right? If you provide the accommodation and it doesn't work or doesn't work very well, then there's no point. So we go from the large class action cases against Harvard and MIT down to a different type of case here, a single plaintiff, a single individual, Argeni, or now it's Dr. Argeni versus Creighton University. And Argeni, very simply, was a medical student. He had applied to several medical schools. Creighton was the only school he applied to that accepted him. He was hearing impaired. He eventually, right before his third year of medical school, 3 out of 4 years, he brought an action under the ADA, under Title III, against Creighton. And the action was that he did not know ASL. He did not know American Sign Language, but he relied on lip reading and cued speech, hand signals to represent sounds. He also used CART. And essentially what happened was that his instructors at Creighton University said to him, in certain clinical situations, when you're with patients, as an example, we don't think you should rely upon some of these interpreters and some of these aids. We would rather see you rely upon lip reading and other ways of communicating because we think that's better for a doctor to communicate with its patient. And Argeni said, well, you might think that, but I need these other accommodations. And the university failed to provide it. So that's why he filed suit. It went to a trial. It did not settle. It went to a trial. The jury ruled in favor of Argeni, the plaintiff, and found that the university had in fact discriminated against him because it would not have been an undue burden to provide some of these services to Argeni. In fact, no good deed goes unpunished, right? One of the arguments that the plaintiff made was they've been providing it. They've been giving it to me for 2 years. They can continue to give it to me. So the university itself has demonstrated that it's not an undue burden. However, the jury awarded no damages because, going back to a few minutes ago, I was talking about good faith. Remember, good faith matters. They found that Creighton had not intentionally discriminated. They thought what they were doing was right. Turned out that they were incorrect, but there was no ill intent and there was no intent. So after the jury made their decision, the plaintiff then filed a motion with the judge, asking the judge to grant more relief. The judge ruled in favor of the plaintiff, in favor of Argeni, and said that auxiliary aids and services, including CART, in didactic education, teaching settings, and sign-supported oral interpreters in small group and clinical settings. He ordered that to be provided from Clayton to Argeni. He also ordered $449,000 in attorney's fees, which is very common to give the plaintiff the money so that he or she is not out the money that they pay for their attorneys, kind of bring them back to normal, and also $30,000 in costs would it cost them for experts or for other costs in the lawsuit. But what was interesting there is the judge did not give him any other monetary damages, no compensatory damages, no damages for pain and suffering, no damages for punishment or punitive damages, because the judge agreed that the university tried to provide the accommodation that it thought was correct, and there was no evidence of bad faith in that situation. So Adam, what about the implications of this ruling?
Yeah, just very briefly, I found this case fascinating because and very telling. So on its face, it would seem that the student simply required card captioning, right? But as we delve deeper, we see that both the student's needs are more subtle, or were more subtle, and the school's requirements also were more demanding. The case really shows once again that accessibility accommodations, especially in an educational setting, never really offers a one-size-fits-all solution. Oftentimes, we find that schools, they don't know exactly what they need, and they're looking for experience-based guidance. So that really brings me to the next slide, and I think it's going to be close to our final slide about choosing your agency. And this is, we were joking, Mike and I, that this is not a pitch. It's not a sales pitch. So I hope it doesn't sound that way. But I do want to note that throughout this presentation, I've outlined several different types of accommodations relevant to the deaf, the hard of hearing, and the blind communities. And we work in these accommodations every single day in all 50 states. We provide them to schools like yours throughout the country every day, and we have for decades. So please remember, when it comes to ADA compliance and these accommodations that we're talking about, don't wing it. Reach out to us for advice and guidance. There's no need to be apprehensive about moving your student-teacher interactions remote if you are prepared. So be prepared, reach out, ask the questions, and who knows, you might even improve your instruction to students by using accommodations such as note-taking or captioning. So I really think here, Mike, we can move on to the question and answer slide.
Sure. I will say, let me just jump in one thing on that on professionals. So on the legal side of it, I'll echo what Adam said. If your entity, your school, your university, your business, or whatever has attorneys that it uses, reach out to the attorneys and ask them about ADA compliance and accessibility issues. Even though the ADA is federal, as I mentioned earlier, many states have their own rules and regulations about accessibility. I will say that normally the ADA, the ADA is the one you're going to look at because it's so detailed and it has technical assistance manuals. There's lots of case law. Usually state law doesn't override or doesn't require something more than the ADA, but some states do, and you might know who you are. But be sure to reach out to attorneys to make sure that they go over your policies, your procedures, things in your handbook, what you publish to students, what you publish to the public. So it could be, it sounds like it could be intimidating, but most attorneys who practice in this area can give you almost like an accessibility audit, a general look of what you're doing right and wrong. So, all right, Q&A session. Yeah.
Definitely.
Yeah.
Right. So this is the time where we can basically answer any questions that you may have. You just type them into the chat box at the bottom of your screen. and we'll be happy to answer any questions coming through. Yeah, I see that a question came in about the audit, but you already touched on that, Mike. And
I actually don't see that. Was that?
Yeah, it's directly
a chat. Oh, okay.
Mm-hmm. All right. Well, I don't see any coming in, which is kind of rare. We usually get. Here we go. I have a question. Are there rules or guidelines for things such as presentations assigned to students in college classes?
Yeah, so I'll take a shot at that one. Are there rules or guidelines for things such as presentations assigned to students in college classes? So I interpret that question to mean, do these guidelines, do these accessibility guidelines and access guidelines apply to presentations? Yes, the answer is yes. So I think what that means is an educator says to a student, you know, I want you to go see this presentation. I want you to go look at this presentation. Now, you know, that's not coming directly from the school, right? You're telling a student, go online and look at this, or go watch this video, or go do whatever. Maybe that material is not accessible, or it's not captioned, or, you know, whatever the situation may be. The answer is yes. If you are assigning a student something and it's relevant to the classwork, and, you know, certainly if the student's going to be responsible to know the content, then you're going to have to make sure that that's accessible to them somehow. So either it's accessible directly, or provide another way to make sure that they can do that. So I think that's the question, but yes, you would have to. It would apply.
Right. So we got a question here, which is going to be difficult to answer. An attendee at a virtual panel presentation, so remote, has identified as deafblind. Right. We have a hypothetical situation like that. So how would accommodations be provided for this person who is participating from their home? So we have encountered situations like this. So just so everyone's clear, there's a virtual panel presentation. So there's a virtual event like this one. You've got 100 different participants, and one of the participants, or one of the participants is deafblind. So what accommodation would be provided? Now, a deafblind individual is typically going to need tactile ASL in order to communicate. So there would be one of the only solutions that I would foresee here, not knowing more detail, is that we would actually send a tactile ASL interpreter to this person's home. They would interact directly with the deafblind individual, and then they would interpret or translate for that individual into the virtual panel. So they would be like a surrogate, and they would be kind of speaking on behalf of that person and translating for him or her. I hope that answers your question.
Adam, we have one here. Maybe this is both of us answering. I'm not sure. It says, how do you evaluate your website for accessibility? I'll tell you from a legal perspective, what's been happening in the last, I don't know, probably, I want to say 6-7 years. You know, you talk about class action lawsuits. There are numerous lawsuits. There are attorneys out there. If you don't want to be kind, you would call them trolls. But they troll for these that's what they're called, actually, some of the practice, and I think they're proud of it. They troll for lawsuits. What they do is they find an industry or a company whose website is not accessible, and they file a lawsuit. And they go through different industries. So, for example, I think they've been through online shopping, websites, and then banking. I know was hit very hard. They were going to various banks, and the idea is that if someone has, if there's a bank, let's say, that has accessibility to the public to do online banking, but the online banking is not accessible to the blind, usually it's for the blind, then it needs to be accessible. It needs to be coded in a certain way so it can be interpreted. There are companies that will go through and properly revise your website and code every page to make it accessible. And it's not inexpensive, I hate to tell you. We did it at our law firm years ago, and it was a little bit of a project to have somebody go through. But that's what I know of evaluating your website to make sure it's accessible. That it has to be coded in a certain way in order to make it accessible for those who are sight impaired. Adam, I don't know if you have any other comments about that, but
yeah, you have to go to a WCAG specialist, a software a designer, website designer, and almost all of them will be able to transform your website into one that's accessible. So, yeah, I don't have much to add to what you said, Michael. We have another question here, which two more questions. So I had a teacher tell me, I'm reading here, I had a teacher tell me that they were concerned about a student's accommodations of extended time. And if they can have that student's exam proctored, but not the other students because of the extended time. So would this not be discriminatory towards the students with a disability?
No. No. I guess the famous lawyer answer, it depends. But pretty much no. Just the fact that you're having another student proctored and the one student proctored and the others are not proctored is not discriminatory. And I'm assuming that the proctor is not interfering, is not doing anything other than sitting in the room, kind of making sure that the person is not looking at, his phone or her phone or something like that. So just the fact that someone's proctored and someone isn't would not be discriminatory, assuming that they're not interfering. I don't see that as, causing harassment or discrimination.
Thanks. We have another question. If a school offers meaning for meaning captions versus CART, and the student doesn't like meaning for meaning, does the school need to switch? So that's the first question. And from the same author, also, if a school is required to provide a different captionist, is the school required to provide a different captionist if the one assigned is not meeting industry standards as far as the student can tell? Yeah. So, in terms of the industry standards, we have had this a couple of times where the school, or the student, I should say, is not fully satisfied, perhaps, with the captionist. And this usually happens, or with the interpreter. This usually happens when a student is simply used to having the same captionist or the same interpreter with them all the time for a long period of time, and then suddenly the agency switches it up and sends somebody in to replace them, and the student is not satisfied with the change. And this is a very important part of our business. This is to ensure continuity, because students develop a relationship with their interpreter, with their captionist. There's a certain vocabulary that each of them share, a certain type of signing that each of them share, and therefore when there's a new interpreter, a new ASL interpreter, for example, it makes it very difficult sometimes for the student. So we, as an agency, we try to ensure consistency to avoid that problem. In terms of the first question, if the school's offering meaning for meaning versus CART, and the student doesn't like meaning for meaning, does the school need to switch? Mike?
Yeah, I can jump in on that one. That's a tough question. And it's a tough question because it's very, very fact specific. So again, just keeping in my lane, in the legal lane for a minute, as a matter of law, you're not required to provide any accommodation that is requested by a disabled individual, or in this case, a disabled or hearing impaired student. So you're not bound to if someone says, well, I want this. Okay, well, they asked for this, so we have to provide this. That's not the law. Although many schools and many employers believe that they have to do that, you don't. But you do have to provide, you have to be reasonable. You have to provide a method by which the student can communicate. The student certainly isn't required to learn a different system. Now, in this case, it wouldn't be learning a different system. It would be like what they're comfortable with. So the answer to the question really is very fact specific about what exactly is going on with the student. What do you mean they don't like it? Does it really create more difficulty for them, or is it just a preference? That's going to be an interactive process, I think, with the student, and if it's applicable, depending on the age of the student, the parents, and maybe the students, medical providers or people who advise them.
All right. So we are going to call it quits. This is the end of our session. But having said that, we would love to answer any further questions that you have. On the slide that you see in front of you, you can see.
Yeah, I'm getting back
our slide.
Yeah,
our slide has disappeared, but that's okay. Here it is again. So on the last slide of the presentation, you'll see our contact details. So please feel free to contact any of us, ask us questions, give us a telephone call. It's really no problem. I know I speak for Mike as well. What's that?
No, I said absolutely. Yes.
Yep. So a couple of closing notes before we leave is we will be sending you a quick survey directly after you get off of this webinar. And we would be really grateful if you could just take a minute and share your thoughts. It's very short. You don't have to answer all the questions if you don't want to, but your thoughts and your comments will help us improve our content for future audiences and maybe for you in future webinars that you participate in. So please also support us in generating more valuable content like this by liking and sharing our social media posts. So we invite you to our social media. As a final kind of note, I've been taught that you should try to finish a presentation like this with a joke. That way the people who've been participating, they are attending, that they have the impression that they've been having fun the whole time. But I think I'm going to avoid that. I'm not very good at jokes, but I will tell you that I'm really glad that you were all here with us today. We had a great turnout once again. And the reason is that by being here, you've really demonstrated that ADA compliance is important to you, and that you've begun to take steps towards improving conditions for the deaf and the hard of hearing and for the blind communities. And I commend you on that. So come back again, join us for our next ADA compliance webinar in the series, and bring your friends. So till next time.
Thank you.
Thank you. Bye.